Hello and welcome to the sixth episode of TLJT Talks. Today we have today we have with us Mr. Sumeet Malik, who's the director of EBC Group of Companies and publisher of Ssc and Ssc Online. He has his name over 24 books. Obviously, the name needs no introduction. So, sir, I'd like to thank you from whole TLJT team for coming and recording with us.
Thank you so much for having me. It's an absolute pleasure.
Thank you, sir. So before we start getting to the questions and answers, I'd first like to ask you that back in 90s there was not this much craze about law. So in the fourth episode, I spoke to Mr. Anubhav Kapoor, who's the director of legal affairs for Ford India, and he said that back in his time, law was not as attractive as it is now. So, what made you choose law over other professions? And since you come from UP, a state where public services are given more importance, or engineering and medical are the professions that people mostly go to. So back then, going to NLS and pursuing law from there, how was it like, and what made you choose law as a career?
Okay, so Aryaman, I am a third generation of a family that is into publishing of legal content. The business itself started in 1942, so we'll be celebrating our 80 years next year. And my father, he had sort of done his law from the law faculty. That was the only one. There was only one law faculty in the University of Delhi, and then he went ahead and did his master's from Columbia University in New York. So that definitely was my first inspiration. And by the time I was finishing my class 12, I have another aunt. She had done her law also from Delhi University, worked with Mr. Sarabji. And then, so she, and we were also sort of, I mean, my father was also aware that the National Law School had been set up in Bangalore. Incidentally, Professor Menon had, though not directly, but had been one of the people who had mentored my father when he was still at university. So he knew of Professor Menon. And sort of that is how my interest, and of course, being a third generation, being surrounded by law books from probably the minute that I was born, while growing up, looking at my father do all the work in terms of reading the Supreme Court judgments and creating the head notes. So there was a bit of a fascination towards the law. And so once this kind of opportunity came up, I just sort of went for it.
Right. So that's very interesting to hear that you are a third generation lawyer. So it's of no essence here, but I'd like to tell you why I chose to become a lawyer.
No, it would be very good to know that too. Yes.
So I come from a family of professors. Like both my parents are professors. My father teaches sociology and my mother teaches chemistry. So when I was in class 11th, I wanted to become a doctor. I chose biology and I wanted to become a doctor. But these coaching institutes, they come to our college to advertise their coaching and brand and everything. So one CLAT coaching from Lucknow, it came to our school, and they told us that lawyers make lawyers are these famous people. They make this much money. You can go to any profession if you go into law and these things. So it just clicked. It just clicked me that in medical I'll study for 10, 12 years and then I'll go for internships. Then at certain age of 40 or something, I'll start practicing. And so that's why I chose to come in law. And being a first generation lawyer, it's like to tell my parents about this thing, that why I want to be a lawyer, and this is the exact reason why I wanted to be a lawyer. Like that one session from that CLAT coaching, it triggered me to choose law.
Okay, I'm so glad that they were influenced. If I can just say just a small thing about the legal education itself. Yes. So what I think is that the legal education, I mean the legal education today in India, or the way that law is being taught, or the education itself is an education which stands you in good stead, irrespective of whether you want to stay in the field of law or not. Because what it sort of does is this whole process of being in a law school with this semester or trimester system, with having to write at least 45 projects or 60 projects, depending on which law school you're in, then having to sort of do your midterms and end terms, gives you a sense of discipline in the way that you are you approach life. Not to say that somebody may not, but overall, it gives you if you follow the curriculum itself and you follow the system of teaching, it's a very disciplined method. And what it does is it disciplines the mind. I am now being told by my friends some of who are running factories or who are running businesses, that they prefer to hire law school graduates in non-law areas because of the ability of all these graduates to analyze information given to them. So I personally feel that it's a fantastic education. And if you choose to remain in the law, fantastic. But even if you choose to look for avenues outside the law, they're there and they're increasing. So
absolutely true. So we have seen top bankers who are lawyers. We have seen other professionals, especially the politicians. Most politicians in India are lawyers.
Yes, that is correct. That is correct.
Yeah. So, sir, moving on and asking you the first question. Sir, there is a misnomer that working in a publication house is not as interesting and appealing as other professions, particularly in the field of law.
Okay.
So, how would you like to counter this argument, and what are the responsibilities that this job entails? Because sir, you being in publication house and you running Ssc Online. We have seen that daily news. There's a specific news section on Ssc Online, so it can be said to be a business of media reporting also.
Right.
So what are the responsibilities that this job entails, and how would you counter to what I said in the beginning?
Okay, so I really don't understand what excitement sort of means. Different people may have a different sense of what excites them. But what I can tell you, that working as in a publication house or being part of a publication house, there are 2 or 3 very unique facets to this. The first most important thing is, which a lot of people now want to sort of start off as soon as they get into careers, is a work-life balance. So there are no crazy late nights. There are no 2 a.m. things. You're not sort of up the whole night trying to sort of reach a deadline. Because if you're able to pace your work and you're able to sort of do it, there is no need to do things like that. The second is what I would sort of say probably more important is a sense of contribution. What is it that you're able to contribute when you're being part of a publication house? And something like EBC, so we publish content for almost every segment. So we have our Bare Acts, we have our student books, we have our lawyers' commentaries, we have a law report, which is Supreme Court cases. We have a legal database, which is Ssc Online. Then we've got an ebook reader. We've just got into e-learning. We've got the Ssc Online blog. So when you're part of an organization like this, your sense of contribution becomes immense, right? And most importantly, because whatever you're doing, nobody can take away from that sense of contribution. So if you have contributed to writing a blog piece which is published and your name goes with it, there is there is instant gratification right there. And importantly, that is going to help not just 1, 2, 4, maybe a few hundred people, sometimes a few thousand people, and sometimes even more than that. Same sort of thing happens in other things. So if you are part of the team that has helped create a student textbook, and that student textbook is accurate, all the information contained in that is up to date, and it gives us an understanding of the law which the student is able to understand. Again, what you have done is you've helped so many students, so many thousands of students to be able to understand and learn the law. So being part of a law publishing organization, I think that anyone who is part of that, their sense of contribution becomes really, really high. And then you're able to sort of go about your life in a manner which sort of is good for you.
Absolutely correct, sir. If I go for internship, if I go for any academic research in my college, They always say that, have you done SCC researching and these things? So yeah, it is about leaving a mark. And sir, while you were saying these things, I'd like to say what came to my mind. So I did my first internship with EBC. After my first semester only, I interned with EBC in Lucknow. So I can't reveal the things I worked on because of the contract thing that we are made to sign. But when I see on the website that, you know, these things, they have my contribution, it gives me immense pleasure. So when you said that thing, it just triggered it. And like you said, the differences that publication houses are making, I have these books right in front of me. I am preparing for my vivas for tomorrow. So I'm started with these things. So,
great.
So, sir, back in 2014, you gave an interview to Super Lawyer where you claimed that legal researching is sort of missing in the new lawyers. What would you say that, like, how do you say we go about promoting the next generation of lawyers to take legal research more seriously?
Okay. So, and this is something whenever I get a chance and I speak to a first year classroom, I ask this question. It's a very rhetorical question. I say, okay, if you have brushed your teeth in the morning, does the person sitting next to you, do they thank you for it? And if you haven't, what is the sort of reaction of that person? So legal research is also very similar. It's what is probably called a hygiene factor, right? In a sense that if you have good legal research skills, if you have been able to inculcate that habit from the very beginning, you whatever you're going to produce, whether it is your project, whether it is an article that you're writing, whether it is your moot court, whatever you're trying to excel, even your your examination, you will be able to do that much better, and you're going to sort of do it for yourself. So nobody is going to say, oh, this person has great legal research skills, because it is sort of a given. If you're expected to perform or you're expected to do your job right, irrespective of which branch of the law, whether you're in a law firm, you're in the chamber of a litigating lawyer, you've set up your own chamber, you are, sitting for or have become a judge. If you are you have good legal research skills and you're able to find the law, because the law is changing, right? Unlike, let us say, the law of physics, the law of man continues to change. Law is affected by judgments of courts. Law is affected by legislative changes. Therefore, if you are able to get the skill of being able to find the law and find the correct position of law, it sort of makes the difference between, if it were a case, between winning and losing a case. Or if you're sort of, say, drafting an opinion, between correctly and incorrectly drafting that opinion. And there's one more term that I'm sort of going to use, which may come up in some other questions that you might ask, is something called exhaustion of search. Okay. And this, a lot of people either are unaware of the concept or probably miss out on. And this is something which a partner at Clifford Chance in the Netherlands sort of told me. I was aware of it, of course, but he sort of clarified for me and sort of brought it into perspective, is that when you are doing research, not only must you know those points of law which are in support of whatever you are putting forth, but also those which are against you. Only then have you exhausted the law or exhausted your search for that particular topic. And that is very, very important. What a lot of people today do is just go to Google, fire a search, find the first 3, 4, 5 topics they come across, do it from there, and sort of that's the end of it. But it'll work for some time, but then as you, and today India has about probably 27 law schools, each one of them 27 NLUs. Add to that all the other traditional law colleges, the government law colleges, the private colleges. So my guess is that they're close to, I had that number, I think between 5,000, no, probably far more number of law schools, law students who graduate every year. So how do you set, or how does a law student set themselves apart from the others? And I think being able to have good legal research skills, the ability to be able to use a good legal resource to be able to find the law is what is going to set you apart. Yes, after that, if you're in litigation, then you need good oration skills, the ability to sort of convince the judge, but your basis. And how is it that some lawyers at a very young age, the court is willing to take their word for what they're arguing in court? Is because they have done their groundwork, they have done their research, and then the judge sort of starts trusting the arguments that are being made by that lawyer. So that is very, very important and critical, that if you have done your homework and you have done your sort of research and you're aware of the law, again, both sides of the law, that which is for you and that which is against you, your rate of success would be much, much higher, and you'd be able to set yourself apart from others.
Right. Sir, you said that law keeps changing. It's not like law of physics. It's because law is derived from society, and society keeps evolving as it has a human element in them, and human mind is never constant. So, and sir, also you said about exhaustion of research. Sir, so with mental element involved, can exhaustion of research be a possibility?
So it's always in a there is a time for it. It's a time period, because whatever you're doing is fixed in time. Yes, there is a possibility that the law will change, but it's not sort of like the Bitcoin. It doesn't sort of the value of it doesn't change every minute or every hour. So yes, new developments will happen, but if you are in the process of you constantly researching, and whatever you're doing is, so if you're writing a project or if you're writing an article, it is for a particular period. So, or if you're presenting a case before a court, that has it is limited by time, right? Because any prospective amendment to a statute may not apply to whatever you're arguing before the court. But whatever it is, till that suit or that sort of list was instituted, till then, obviously, whatever has been said must be included.
So will it be wrong to say that you believe legal researching is the most crucial part of a lawyer's life?
If you ask me personally, I think being able to do good legal research is very, very critical.
Right. So, sir, from your experience, is there any specific manner in which, like I, for example, being a law student, if I have to go and write a research paper on a topic, so from your experiences, what would you say of how I should go around a topic? Like I have seen my batchmates, also my friends, how they write, how I write. So when I write, I do a timeline study. Like I go back to the ancient period, and then I come to the present time, and then I find a link between those things. But is there any specific way to go around legal researching?
No. So I would say that there can't be a fixed method, because it totally depends on what kind of research that you're doing and what is the topic and how does it relate. If it is something which is absolutely new, or there is very little legal literature on it, the way to approach it might be a little difficult. If it is already something which is a settled position of law, and your research or your sort of article is that you either agree with it or disagree with it, then the methodology is slightly different. But primarily the idea is that you must first understand the concept, and you can utilize a book where if that is already been explained, or if that concept is already there, read and understand from there the concept. Then you must read the articles that may have been written on that particular topic, because law is one particular topic or subject or area where it is not in isolation. There has to be a reference to the literature that is already available on that point or on that issue or on that whatever you're trying to do. Then is very, very important to refer to the primary law, that is the primary law. That is, statutes as well as judgments if they are part of what you're researching, right? So if that topic there is any sort of judicial interpretation in the form of a judgment, then it is important to read the judgment. It is also important to read the statute. So, and this interplay will sort of keep happening. Once you have read the judgment, you might get certain thoughts. Then you may be able to see that has somebody else looked at that aspect of the judgment? Have they sort of spoken about it? Have they criticized it? Have they supported it? Have they sort of disagreed with it? And that is where you will sort of start forming your views. And then you can sort of start writing. And then again, this sort of back and forth between primary materials and secondary materials will sort of keep happening. And I would say that you must read the primary sources, that is the cases, judgments, as well as the statutes. I find it very surprising when I receive articles. So we receive between 1,000 articles every year. When somebody cites that the recent or the courts have decided something, and then they cite an article by somebody else, or they will cite a report about a judgment from a particular site. That clearly shows that you've not made the effort of sort of reading the judgments, because if you are saying that a particular judgment has decided something or the other, then that judgment and its citation must be mentioned, not somebody else's opinion about that judgment.
So maybe it's because of the advent of technology these days. We can simply we can simply press Control F and find the things of our relevance in spite of reading whole judgment. So which brings me to the next thing I want to ask, that how is legal researching different now to what it was back in your time? Because that time it was only SCC, not Ssc Online.
So I was in law school from 1994 to 1999, and we had sort of launched the CD-ROM edition of Ssc Online in 96. So, but the first 2 or 3 years, it only contained the digest notes or the head notes from SCC. So, I mean, I keep having these conversations with seniors of mine who were 2 or 3 years senior to me, so NLS sort of became the blessed place because of the fantastic library that it had. So in terms of resources, there were 2 or 3 people who donated a lot of their library. So the richness of the library of the NLS library at that time was great. And what people were not able to find the NLS library, they would spend months. So if there was a moot court for which they had been selected, then they would come to Delhi and then go to either the ILI library or the international, India International, the one that is next to this one, and they would next to ILI, and they would go there and do their research. So now I think legal research has, if I can use the word, democratized to a huge extent. Almost all the information that was available just in those books or on those law reports or on those printed material is now available online on these databases, and it's very easy to get access. And almost all law schools today subscribe to one or multiple databases. So the ability to be able to do the research, and now there can be very little excuse to say that, oh, I didn't have access to this material, I wasn't able to do it. Because even if you're not able to get the primary material itself, you will get some reference to it from Google. So you can start over there. You can probably get your list of resources from there, and then try and get to the original document by accessing a database which has that.
Right. So we have access to everything. That's what has helped us during these COVID times when the law schools turned online.
Yes.
So one thing, what challenges did you face as students that you try to encounter while working for SCC Online?
Okay, so the first thing sort of was, challenges that I faced while doing legal research and how I tried to implement those in SEC Online. If I understand your question correctly,
Yes,
is
sir.
that what you mean?
Yes, sir.
Okay. Yeah. So going back to the previous question that you had asked, that a lot of the content was sort of only in books. So if you look at the progress of SEC Online, it started with just the head notes of the judgments that were published in SEC. Then we added the full text of the judgments of the Supreme Court. Then we started adding content from high courts. Then we started adding content of the central statutes. Then all the rules and regulations, by which time by the time we got to the mid 2000s, the number of tribunals and commissions had increased. So we added content from those tribunals and commissions onto the database. Then the next thing what I thought might be important is comparative law. So a lot of the Commonwealth countries, and this is something very interesting that I found, that when a judge is referring to the judgment of another court, they kind of end to treat them as co-equal courts. So whatever might be the political issues between India and Pakistan, but the Pakistan Supreme Court refers to Indian Supreme Court's decisions. Indian courts, the Indian Supreme Court refers to which is erstwhile House of Lords, now the UK Supreme Court. Similarly, judgments from Australia, New Zealand, South Africa. In South Africa, they refer to so many judgments from the Indian Supreme Court, and vice versa. You would the basis of the 377 judgment comes from a South African judgment. So that I thought would probably be a good idea. So we've added judgments from right now from Canada, from the US, from about I think 17 odd African countries that follow the common law system. We're trying to add content from Pakistan, from Bangladesh, from Malaysia, some from Singapore, so that issues that some of those jurisdictions which are faced. See, human issues are probably same across the world, right? And usually the solution to them is also very, very similar. So it's not necessary that you may or may not be able to cite the judgment of a particular court in another court. Even if you're able to use the arguments that were put forth before that court and use it successfully to your own argument, it works. So, and I think a lot of the smart lawyers who have sort of understood this and if the courts, they will see the judgment of the other court, and if that court doesn't, nothing stops you from making your argument before the court.
Right. So as we were speaking of legal researching, which brings me to the next topic. It's about publication. So there's a word around us that international publication have more fame. So we should try to choose topics that impress them. We should go for international publications. So how well is it grounded in facts, and what are the key differences that you see when research papers or articles are sent for publication in an Indian journal or blog publishing, and when sent for an international publication?
Okay, Aryaman, I'm going to try and answer this question a little sort of differently. In the 70s, it was probably thought that foreign cars were the best, and so they were getting imported in what we were produced in India. And similarly, if you look at that for other products again, so there is nothing right or wrong about a foreign or an international publication, right? What sort of is how good we want to make our own system, our own legal system, our publications, our legal literature. How strong do we want to sort of make it? So there was a time when all the these law review journals across the country, some were being published, some were, the periodicity was not there. And I can take just maybe that just a little bit of that credit and say that I've worked with all these law review journals, and I keep sort of telling them that there is a need for consistency. You have to be consistent. You have to keep producing the content. You have to keep sort of bringing out the issues, and your process of selection must be very, very strict. Okay, so there has to be a proper, if you're saying you're a double sort of blind peer review system, then you must follow it, right? So why should not a law review or the law reviews coming out of the law schools be as good as a Harvard or a Columbia law review? It totally depends on us as a community. So from law students, from professors, from teachers, and then also the judges. If judges start, a few do, not too many, but if judges start looking at all this literature that is being sort of produced, and they find that there is something useful, and they're able to cite them in their judgments, that is what is going to strengthen the whole ecosystem of legal writing, of legal publishing, and then the quality. So quality will come. I mean, already there are some, the quality is already there. And I would say that these, some of the law review journals today are on a par with the others which are being published internationally. So I don't think too much of emphasis should be given onto this whole thing of international or foreign versus domestic. The whole idea is that we need to strengthen the ecosystem here so that we become so good that this whole debate or this discussion sort of goes away.
Right. So you spoke about developing an ecosystem where we became so strengthened. So it brings me to my next question. That is, so us going to foreign publications for getting our articles or papers published, it gives them the right to use our articles to monetize it the way they want. And in this way, it's the credit of our country. It's the credit that should be given to our country, which someone else takes. So
right.
So, like you said, an ecosystem needs to be developed. So, what are the steps that are needed to be taken on that road to develop that kind of an ecosystem in India? So that we are more interested in sending research papers to an Indian journal rather than sending to a foreign journal.
Right. So I'm just going to carry on from the last answer and say consistency is one of the most important things, because usually what happens is that there might be a 2 or 3 very enthusiastic students who say, okay, now let us start a new law review while we're at law school. And they're, I mean, probably when they get into their 2nd or 3rd year, and by the time they're in their 5th year. So do it. It's great. I mean, that is how so many today, so many law review journals have come about. But while you're doing this, also think what will happen when you have passed out of law school. Will the legacy continue? Are you building enough systems while you are sort of heading those journals to make it such that when you have passed out of law school, does it continue? Even when you have passed out of law school, there are some students who are, I mean, the ones who initiated the journal and keep associating with the journal. Give help, guidance to the students who take over once you have graduated, right? That is how you're going to sort of build like strength to that particular journal. And also collaboration, I think, is a very, very important thing. So collaboration amongst the law schools. So it's better to have fewer journals, but of higher quality than say having multiple journals and they not being published, or they not being produced, or they produce, mediocre articles. So that's what I would sort of suggest, that it is both incumbent on the student community as well as the faculty of many of the law schools to support this ecosystem and strengthen it, and to sort of put in, and ensure that there are that higher quality. So even if it is a pure student-run initiative, nothing stops them to whoever might be the faculty or who might be the subject experts teaching at that law school. And now a lot of law schools get sort of visiting faculty that just ask them, can you please review this article for us? Or if there is anything more that you feel that the author might have left out, or any feedback for the author. And sort of that is how I think this ecosystem will become stronger.
Yes, so you said a very good thing that so I just implied from that a good leader is the one who establishes a second line of leadership also within his or her firm or organization. Right?
Yeah.
So as we are talking of publications, plagiarism is something that is not left behind. So how do you think the original content from authors of any paper it stacks up on the ones that are cited? Because conclusions and implications they can be speculative and not well grounded in research, or it's like we already discussed, it's with the mental element of the author. So what specific weightage should personal contribution and citations be given?
Okay, so what I understand correctly, I mean, there is very little element of plagiarism in your question at the moment. So what you're saying is that what is the value of the person who is writing the article, her views vis-a-vis the sources that person is citing, right? So I'd mentioned this a little earlier in the interview that we are part of an ecosystem, right? So we cannot suddenly come up with a thought or an idea which is bereft of the legal literature that is already there. So what you have is when you're writing an article specifically is to first identify an issue that you feel is what you want to write about, and then you are sort of giving your views on that particular issue. And while you go about doing this process, right, there are and if you've exhausted your search, if you exhausted the law, you will know that in the current literature, what are the things which are in your favor, or what is it that, I mean, which is in your favor, or the whatever that you're arguing for, and that which is against you. Okay. So when you take that into account, what happens is that the debate becomes much richer. You have already referenced and you have said that this has already, I mean, this is the material that is already published. And then for these reasons, I agree or I disagree with what a person says, right? So therefore, you can't sort of say that is there more value. So each person who does this legal research basically adds to the whole ecosystem and adds to the legal literature that there is. And that is how there is progress. So that is sort of how the law develops, or the understanding of the law develops. So the value of the person who has been cited is one, but obviously it's the author who is writing that article has to, whatever conclusions they're coming to must be based on some logical understanding. You can have a completely different view. I'm not saying that you have to say that, okay, I mean, this is the view and therefore I'm bound by it. No, that's not what I'm saying. Whatever, if you disagree with it, fair enough. But whatever your sort of your disagreement is, has to be logical, and it has to be sort of clearly laid out. Because if there was just one view, then the law would never change. We would never have, so I mean, 377, look at that as a very, very simple example. It was on the statute books for close to 1860 to this 180 odd years. And then you had the Supreme Court reinforcing it and saying, no, that is the correct position of law. Yet those who felt that it was not correct kept at it. There was legal articles that kept coming out. There was, and then finally the law changed.
Sir, is legal researching like a legacy that should go on? Like we take material from someone, written from someone, like we get into mind of someone and then connect our mind with that person, and draw a line and continue it? Is it like running with a baton, and when someone drops it somewhere, we just pick it from there and run farther, and then someone else will take it from us and run even farther?
In a sense, yes. In a sense, analogy that you've given, I've never thought of it in that way, but yes, I could sort of put it in that way, that yes, it is quite literally like picking up the baton, because the person A may have sort of run the first part of the relay and sort of explained or brought about the legal position till that, and then you kind of pick it up from that point and run B part of the relay, and it's not necessary that you would again, I'm saying this, you would be running in the same direction as person A. You can be running in the exact opposite direction as person A. That does not mean that you're turning the wheel back. Even a contrary view sort of given with cogent reasons and with cogent backing is as valuable as running in the same direction. So you could be running in the either directions, but you are sorry, you are contributing to the legal literature, and you're doing it in the way that it should be done.
Yes. So one question that I asked, like one part of question that I asked, we can relate it with this. So when we pick up the baton, do we, like you said, we don't have to necessarily run on the same track. So yeah. To what extent can we follow those footsteps? Which brings me to what I asked. I'll reiterate it. What specific weight is the personal contributions of author and the citations received? Like, how much should we cite and how much should be our own contribution? For example, in 1,000-word articles, how much should we take from the source and how much should we, write on ourselves?
Look, it's very hard to lay down hard and fast rules, in the sense that to say that 75% should be your own and 25% should be cited. What you're doing is there is an issue that you've identified, and then you're building an argument either yes, supporting that issue, or you are sort of disagreeing with that issue. Okay. So there may be a possibility that if you are the legal literature that is available may be completely different to what you have in your mind, and what is it that you're trying to say. So it would completely depend on the article, the issue, etc. So there can't be sort of fixed rules to say that it should be 40-60 or 50-50 or 25-75. And your own opinion will hold value. Again, if I said, if it is backed by cogent reasoning and some sort of, I mean, you may not be able to always get a direct authority on what you're trying to say, but you can always draw from other people's writings, and that is where you sort of cite them and say in a paramateria situation or something which was similar, this has been said, and I sort of draw from it, or even sort of completely disagree with the current literature and say, okay, I don't agree with this, but for these particular reasons, which then have to have a logical sense and a meaning.
Right. So very well explained. So it brings like I had mentioned the term plagiarism earlier only, but I didn't ask anything about it. So one American playwright, Wilson Wisner, he said that if you steal from one author, it's plagiarism, right? And if you steal from many, it's research. So what do you think about it? Do you agree with what is said? You want to counter it, or how is it?
No, so I think it's a little simplistic. I mean, when you so if you just simply copy somebody else's piece and pass it on as your own, that is direct and absolute plagiarism. When you are, and you can also plagiarize an entire article where you've taken, and if say it's 1,000-word article and you pick each of those sentences from different authors and just piece it together. It's as much plagiarism as is having copied the entire thing from somebody else. When you say, when you're reading other people, when you are trying to understand their viewpoint, what you're doing is you're assimilating those thoughts, and then you are putting your own view to say as to whether you are in agreement with them or you're in disagreement with them. That is what is basically a dialogue. So piece or a legal writing piece. And it's very, very important. And I think that any person who sort of does legal writing and sends it out for publication must acknowledge where the thought or the idea is coming from. Even though strictly under copyright law, there is no protection of ideas, there is only protection of expression. But if you are intellectually honest, right, and you are able to bring forth this, your article itself becomes more valuable, because whoever is reading it says or feels that here is a person who has taken into account the views of others and then given his or her reasoning to agree or to disagree with them. Okay. Whereas if all you do is just copy from others, then what you're saying may not be taken as seriously as you would want it to be.
Right. So you earlier said that you receive around 1,000 papers or articles for publications.
Yes. Yes.
So
yes.
So with your experience, how have you seen the force of plagiarism report on what the authors write? Like, just to avoid plagiarism, are they answering the questions that not many people are asking? Are they beating around the bush, like we say, or like how are they trying to avoid plagiarism? And like, this is what I was.
Yeah. So plagiarism is an issue that sort of very seriously needs to be looked into, and it's simply wrong because you are trying to ride on the efforts of somebody else and trying to get credit for something that you have not done. And the way around plagiarism is very simple. All you have to do is footnote or acknowledge what the other person has said, right? What that does is that it, as I said, it makes you, one, intellectually honest, and you are taken more seriously. So it's not that you will not get caught today with so much of the information sort of already available, even from sort of closed sources, in the sense that you may think that you have copied something from an obscure book, but Google having digitized all those and you run a thing, it will find, I mean, it will just catch it from where you may have copied that thing. And we do get it. And we get people who, Aryaman, I must say that the levels of plagiarism I have noticed are coming down because people are sort of realizing this. And if we get an article and we find that somebody has plagiarized from another article or just copied content without acknowledging it, and not just for articles, it includes manuscripts. For us, we blacklist that person and we will never accept another article from that person. So I'm sure that, and I hope that other platforms and other publishers who publish content are also mindful of this particular thing, and they're able to sort of implement it in their policy. So, and what it does is, most importantly, it affects your reputation. If you may be able to get away with it in the beginning, or you might be able to get it in the instance, but remember now, the internet has a memory that cannot be cleaned out. So if you have put out a piece, even if it is in a book or if it is in an article or in a closed publication, they will somehow, and you have copied or you have plagiarized and you have not footnoted properly, and then your reputation is going to be so badly hard to repair. So don't do it in the
Right.
Because the solution is very
Right. So can you hear me?
I can hear you. I can hear you.
Okay. Okay. So yeah, so very well explained. Now moving ahead, most of these articles or manuscripts or research papers are sent to you by college-going students or scholars of law.
Yeah.
So considering the quality of research being done by scholars in higher education institutions and plagiarism of such work, are the guidelines on plagiarism in consonance with what is required standard? And with required standard here, I don't mean what is written in black and white but I mean what is morally correct, what is ethically correct. So before you answer these question, I'd just like to give a gist of these UGC regulations for the sake of our listeners. So when we give any write-up, any research material, any article, we have to give an acknowledgement that whatever we have written is our true research work. The supervisor has to provide a certificate that this is a bona fide work of such and such person on such and such topic. And then this guideline says that you have to put bibliography, you have to put citations, you have to acknowledge whatever you take from an author or someone. Then there is this one clause that says no 14 words in continuance have to be replica of what is written somewhere else.
Okay. All right. Okay.
Yeah. So these are the guidelines. Now, if you could answer my questions, sir, please.
See, guidelines are in place, and similarly, if we look at other things, there is under the IPC, there is a section which criminalizes murder. There is a penalty. I mean, or there is a punishment for murder. Similarly for rape. But I mean, the question is, are they adequate enough? Does having section 300 and 302 in the penal code or having section 375 in the penal code, has it stopped murders and rape? So yes, all these guidelines are in place and they will serve some purpose. But ultimately, what we have to go back in the question, and especially when it comes to legal writing and plagiarism, is if we have a correct sense of what is right and wrong, and we want to be intellectually honest, and we want to be taken seriously, and we want our research to be sort of accepted, then why plagiarize? Why take a shortcut? Why sort of because the difference I mean, and the effort, it will only help you. I mean, it will help the person who is doing that research to be a better person in the work that they are wanting to do. If you can read content from others, analyze it, and then sort of put in your own viewpoints. And what is good about legal research is that you can always refer to what the other person is saying and acknowledge them. And say, in this particular article, this person says this, and I agree with this person for so and so reasons, or I disagree with this person for so and so reasons, right? So therefore, the reason to plagiarize or the reason to sort of do is simply that you're trying to be lazy, you're not wanting to do your work, and you're just taking shortcuts towards it. So don't do it. That's my advice. Whether there are UGC guidelines, whether they are not, fine, they will have a place, or they are sort of there as a formal method to try and sort of discourage people from plagiarizing. But if in ourselves as a member of the legal community, we know the sense of right and wrong, then I think we should be okay. That's what I feel personally.
Right. So with this question, you answered the next question also that I was going to ask. So I'll skip it, but just tell what it was about. So it was about the penalties that are mentioned in these regulations, and your thoughts on whether they are relevant, or whether they are deterrent enough to prevent plagiarism or not. But now, since you answered it, so I'd like to put throw a light on what those penalties are. So if the plagiarism is
Sure. Yeah.
yeah. So if the plagiarism is between 0 to 10%, then it is considered to be of minimal quality and there is no penalty. If it's 10 to 20%, then the researcher is asked to submit the manuscript again. If it's 20 to if it's sorry if it's 10 to 40%, then the researcher is asked to withdraw the manuscript and submit it again. If it's 40 to 60, then again asked to withdraw the manuscript and the guide is denied one annual increment, and the guide will not be allowed to supervise any new masters, MPhil, PhD student scholar for a period of 2 years. And the third level is similarities above 60%. Here again, they are asked to withdraw the manuscript, denied right to 2 successive annual increments, and they should not be allowed to supervise any new masters, MPhil, PhD student scholar for a period of 3 years.
Aryaman, I think the connection was okay. Can you hear me now also clearly?
Yes, sir, I can hear you.
Okay, so I'm just going to make a very small comment. What I understand now that you've read them out to me, I wasn't aware of, the exact things. These are in place for a very, very specific purpose. These are meant, from what you've read, is in terms of probably law teachers and connected to their increments as well as their promotions, if I understand that correctly. So in that formal setup, yes, there is a need to have a corresponding responsibility or a liability where the person does not follow the norms. So, so while I reiterate what I've said earlier, what I said, that was in a very general sense of somebody who is wanting to publish their content. And I think the UGC guidelines are in for a very, very specific purpose as to where somebody who violates the norms of plagiarism or of legal writing or ethical legal writing and does not follow it, then consequences will follow in terms of fines and penalties, or in terms of losing increments or losing promotions, etc. But I still sort of, if I can put it in this context, if you knew that one of your professors was plagiarizing and submitting plagiarized content, what would be your sense of respect for that person?
I would try and never do any research project under that professor, for sure.
Absolutely. So that is sort of the other, that is the thing that should be more important to somebody, that if they are in a position where they are mentors, teachers, guide, then there is a standard that they have to set for themselves first. You can't sort of be plagiarizing content and telling your students that when they're submitting their projects, there should be no plagiarization. So I think it kind of works in that sense. But those guidelines are there for a particular purpose, and I think for that purpose they're all right.
Right, sir. And like you said, it's always about the reputation that you want to leave.
Yes, absolutely.
And being honest with yourself.
Yeah.
Sir, while I was reading these guidelines, just my eye caught something. Sir, it said that higher education institutions need to provide with a plagiarism checker software to the students, faculty, research scholars, and everyone.
Right.
So these days we have these plagiarism checkers and all. Okay. Back in your time, when technology was not in place and everything was manual, how was plagiarism checked back then?
There was very little. There was no way to do it. And there were people who would copy because there was no way that the person who was checking or evaluating would know the difference. So that, it did happen. So it did happen. That's why I said that I have noticed that the articles that are coming to us now and we are less and less plagiarized, because people understand and realize that both the things, that it's very easy to get caught. So I don't know which of the two factors is working because of it? I mean, is it because now it's just very, very easy to get caught? Is that what is making people do that? Or it's a sense of ethics and a sense of morality? I would hope that it's the latter, but even if it's the former, but it means that there is less plagiarized content from probably when I was in law school, and there was just absolutely no way to check.
So we were taught a lesson in political science by one of our professors. So I don't remember the story exactly, but there was one I think minister in a court of a king who was very loyal to the king, and once he found a ring that made people invisible.
Okay.
He found that ring. He had put it in his hands, and he then went on and murdered the king, married the queen, and got the throne. So the essence we drew from it was that we only perform well when we are being watched.
Okay.
And what I'm getting at is we should always do what is right, irrespective of whether someone is watching us or not.
I would agree. I would agree on that completely. But
in that way, like you said, both reputation and honesty will be maintained.
Yeah. Oh yes, absolutely.